Welcome to the DC Voluntary Sentencing Guidelines training on changes to the 2022 Guidelines manuals and scoring out-of-district offenses. This training has been developed for practitioners who use the guidelines. Before we get started, I want to introduce you to some of the Commission's staff that you may interact with as you're getting ready for or going through sentencing hearings. My name is Lyndon Fry. I have the pleasure of being the Commission's Executive Director. You may also interact with Megan Buckley, our Attorney Advisor. She's usually the direct point of contact for anyone making inquiries about how the sentencing guidelines rules work or should be interpreted. You may also hear from time to time from our outreach specialist, Brittany Bunch. This training is going to focus on the minor changes to the 2022 Guidelines manual, including steps in identifying the current DC offense that most closely matches an out-of-district offense, what to do if there is more than one possible DC statute that closely matches an out-of-district offense, what to do if there are no comparable DC statutes to an out-of-district offense, and the process for challenging a decision regarding an out-of-district offense. We'll also talk about scoring offenses where the conduct occurred before the defendant's 18th birthday, and scoring convictions from territorial and foreign jurisdictions. The overarching principle when we're talking about scoring prior out-of-district offenses is trying to make it an apples-to-apples comparison. So treating the defendant in a similar manner if their prior convictions had occurred in the District of Columbia. So convictions and adjudications for out-of-district offenses, including federal offenses. So when we use the term out-of-district, we're talking about any non-DC code offense. So for those offenses are initially scored like the closest comparable DC offense. So we're trying to find the DC offense that best matches it, and we can then treat the prior conviction as that DC offense would be treated. So changes to the 2022 Guidelines Manual. We've made a non-substantive change to the single versus multiple event rule that we'll talk about in a little bit. Talk about scoring out-of-district convictions and adjudications and the very minor substantive rule change that's been applied there. There's also been a modification to section 3.1 about what factors a judge may consider at sentencing. We've expanded those factors when there's a sentence being determined for a hate crime or when the victim or the defendant was targeted in a discriminatory manner, because there may be occasions when things like race, sex, gender, sexual orientation, things like that may actually need to be considered during sentencing. And then finally, we added a glossary term to define a compliant prison sentence, because while we defined other sentence types, somehow along the lines, that one was left out. So it's in there now. But the only one of these that's a substantive change is that there is a minor substantive change to scoring out-of-district convictions. And we're going to talk about that right now. So in the 2021 manual, the manual you probably currently have on your computer right now, scoring an out-of-district offense starts by looking at the name of the out-of-district offense and the elements of the out-of-district offense. Now that's still true in the 2022 language. However, before looking at the name and elements of the offense, pre-sentence report writers are now instructed that they should look at how the offense is listed in the defendant's criminal record. So what's actually written in the record, because that can give clues as to what offense this should be converted to in ways that sometimes the name of the statute or the element of the statutes don't. So you're going to start under the new rule by looking at the name of the offense of the out-of-district conviction as listed in the defendant's criminal history. And that's initially going to be done by the pre-sentence report writer. Then we're going to look at the noted statute in the defendant's criminal history. So if there's a statutory citation associated with it, Then once we've determined what the statute is, either from that statute or based on the name of the conviction, look at the title of the statute and the elements of that statute itself. Now, another change is that the guidelines now explicitly say if the elements of the out-of-district statute are not listed in the statute itself, and we know that does occur. There are some statutes that say things like, it shall be a crime to commit aggravated assault without actually explaining what aggravated assault is. Or if it's a common law offense where there actually is no statute. And previously, it was always implied that in cases like that, you could look at case law to determine the elements of the offense or jury instructions. And we've now actually specified that those can be looked at. So if the elements are not explained in the statute, you can go to case law to get the elements, or you can go to jury instructions. So those are the two minor substantive changes. Is one, you start out by looking exactly at how the offense is listed in the defendant's criminal history before looking at the statute itself, and also what resources can be considered if the elements of the offense are not laid out in the statute. So how does this play out in reality? Well, if we look at a conviction for Maryland robbery, under the 2021 manual, a Maryland robbery conviction was initially scored as matching both robbery and attempted robbery because the Maryland statute puts robbery and attempted robbery in the exact same subsection. So if you just have the statutory citation, you're not able to tell if it's a robbery or attempted robbery conviction because they're both listed essentially right next to each other in the same section. So under the 2021 manual, what the CSOSA pre-sentence report writer would do is say, okay, this offense could match either robbery or attempted robbery, because based on the statute, we don't know which one it was. We initially scored it as the least severe offense. The guidelines have a rule of lenity generally and specifically in regard to scoring out of district offenses. So if you can't make a determination between two offenses, it gets initially scored at the least severe. So the least severe offense in this case would have been attempted robbery worth 1 point, and it would be scored, like I just said, as attempted robbery with a footnote saying it could have been robbery or attempted robbery. It was scored as the least severe one. Under the 2022 manual, we now know that in a defendant's criminal history score, or in a defendant's criminal record, a robbery conviction will be listed as robbery. An attempted robbery conviction will be listed as attempted robbery. So the pre-sentence report writer can now use that information in making the determination of which offense this was. And therefore, we can now know that this was a robbery offense, not an attempted robbery offense, even though the elements are still in the exact same part of the statute, and the offense can initially be scored as robbery. There's actually not many situations when this occurs. Maryland robbery is one of the most common ones. Another one is when you have out-of-district drug offenses. The statute itself may list many different drugs that the statute applies to. Cocaine, heroin, ecstasy, they all may be criminalized at the exact same level in the statute, but it doesn't tell you which offense which drug the defendant was actually convicted of distributing. However, it's almost always indicated in the defendant's criminal history record. So if it says conviction for quid cocaine, CSOSA can now bring that forward as a quid cocaine conviction using that information from the criminal record. So like I said, this doesn't come up a lot, but there are a few prior convictions that the scoring may change because of the information we can now use from the defendant's criminal record. And of course, the defense can challenge this information if they think it's incorrect before the sentencing judge. So what's the procedure that pre-sentence report writers use for scoring out-of-district prior convictions? Well, they consider whether there is more than one DC offense that closely matches the out-of-district offense based on the name of the offense as listed, the name of the offense as listed in the statutory code, and the elements of the offense. And then they score the least severe matching DC statute. So they look at how DC ranks the offense. If DC ranks the least severe statute as a felony, even if the out-of-district jurisdiction classified as a misdemeanor, it's going to be scored as a felony because we're trying to treat the defendant as he would have been treated if all those prior offenses had been scored in DC. The reverse is also true. If the out-of-district jurisdiction classified as a felony, but DC scores it as a misdemeanor, it gets treated as a misdemeanor. Pre-sentence report writers are never looking at the underlying conduct. They're only focusing on the name and elements of the offense. If there's more than one possible DC statute that closely matches an out-of-district offense, the pre-sentence report writer should be adding a footnote indicating all of the possible matching offenses and to tell the judge and the parties that the least severe offense was scored in this case. If there's no comparable DC statute to an out-of-district offense, special rules apply. If the out-of-district jurisdiction classifies the offense as a felony, it's worth 1 point on the defendant's criminal history score. If the out-of-district jurisdiction classifies it as a misdemeanor and the maximum penalty in the out-of-district jurisdiction is 90 days or more, it gets scored as 1/4 of a point. However, if it's classified as a misdemeanor and the maximum sentence is less than 90 days, it's not scored at all. Just as misdemeanors in DC are scored if the maximum punishment is 90 days or more, but not scored if the punishment is less than 90 days. If it's a non-comparable felony adjudication, it's 1/2 point. If it's a non-comparable misdemeanor adjudication, it's not scored, just like prior adjudications in DC are not scored for misdemeanors. And this is an important and, we do not score offenses where the conduct of conviction has been decriminalized in DC. So for example, a possession of marijuana conviction is never going to be scored because that's decriminalized under DC code. However, you as a party can challenge a criminal history score. You can challenge saying, look, the determination of whether or not this matches the right DC offense or right DC offenses that they chose from is incorrect. You can argue that to the judge. However, you can also argue the facts of the case, of the underlying conviction to the judge. And if you prove by a preponderance of the evidence that the facts of the case would show that it matches a different DC offense, the judge can accept that finding, determine you have proven that by a preponderance of the evidence, and change the criminal history score. As a general rule, the sentencing guidelines prohibit plea bargaining in regard to what box the defendant falls in, what their criminal history score is, what their guideline range is. Those are not eligible for plea bargaining. But there's one exception to that rule, and that's the scoring of out-of-district offenses. And this exception is put in place so that if the parties want, there can be a little more finality in how a defendant's criminal history score is going to be calculated at the time of plea. And so if the parties agree on how an out-of-district offense should be scored, CSOSA should respect that scoring, as should the court. So if both parties come together and agree something should be scored as a 1-point felony, CSOSA should accept that scoring, and so should the court. When we're looking at how an out-of-district offense is scored, we're not looking at the actual sentence imposed. However, there is one situation where the sentence imposed may help determine which offense the out-of-district conviction actually matches. And I'll use an example to highlight that. So in North Carolina has the offense of breaking and entering. And this offense criminalizes both a misdemeanor element, simply breaking and entering, and the felony offense of breaking and entering with the intent to commit larceny. But from the statute alone, you can't determine if it was the misdemeanor offense or the felony offense. However, the sentence the defendant received may allow that determination to be made Because the statute gives the misdemeanor offense a 120-day statutory max. So if the defendant received a sentence above that 120-day amount, you'll know that he was convicted of the felony version of the offense. And then the scoring can be based on which offense closely matches the felony version of the North Carolina offense. So that's the one time you can really look at what sentence did the defendant receive to making the determination of what part of the statute should be compared to determine which offense it closely matches in DC. There are a few times that CSOSA does not need to determine the exact offense that an out-of-district offense closely matches. And that's essentially when it wouldn't change anything. So if the number of points assigned to the conviction wouldn't change depending on which DC offense it matched, they don't need to make the actual determination. Similarly, if it wouldn't change the column the defendant fell in, so if it was column A or column C or column E, if that wouldn't change, then they don't need to go through the entire process of determining what an out-of-district offense converts to. And similarly, if a defendant already has 6 or more criminal history score points, it's not necessary because 6 is the max. So once you get to 6, it just goes all the way up to infinity criminal history score points. Seen as around 15, but maybe it's slightly higher than that. But either way, what the pre-sentence report writer is interested in determining is what box the defendant actually falls in and what their applicable criminal history score range is. So as long as they can make that determination, they may not need to figure out exactly which offense an out-of-district conviction matches. Now, there's one issue we've seen from time to time with pre-sentence report writer scoring, and we've worked with CSOSA to avoid doing this, but I want to highlight it for practitioners just so you know to be on the watch for it. And that is when the defendant has multiple prior out-of-district convictions that fall within the same event. So for example, if they had a prior PWID and CPWL convictions, historically, some CSOSA pre-sentence report writers would say, aha, we have a conviction that matches PWID and a conviction that matches CPWL. So when they're from the same event, so if you put the two of them together, we'll know that this matches a PWID well-armed offense. And while that may be somewhat logical, that's not how the guidelines operate. The guidelines are only scoring the actual offense of conviction, not the underlying conduct. Therefore, unless there was a PWID well-armed conviction, each of these two get analyzed separately because they're from the same event. They would both be scored as a point, and the pre-sentence report writer would just pick one. Again, because it doesn't really matter, we're scoring the more severe offense from a prior event. These are both 1 point, so dealer's choice. So I'm going to use a couple of examples to hopefully clarify some of the topics and some of the information that I've been over. So if we look at Maryland theft, Maryland's current theft statute has a $1,500 felony threshold. So if the amount in controversy or the amount of the item stolen is $1,500 or more, in Maryland, it's felony theft. If it's less than $1,500, it's misdemeanor theft. How does a conviction get scored in DC? Well, if it's a prior Maryland felony theft conviction, you're going to know that it converts to first-degree theft in DC because first-degree theft in DC has a $1,000 threshold. $1,500 is more than $1,000. So we know all those Maryland theft convictions are going to match first-degree theft in DC. Again, we're looking at the current Maryland statute. You might have to figure out when this occurred because Maryland's threshold has changed over the years. And if this was a conviction from 1995, when Maryland's theft statute had a $500 threshold, it would change the analysis. But for this point, we'll just assume it's $1,500 in the statute. So we know if it's a felony Maryland theft conviction, it's scored as felony theft in DC. But what about misdemeanor theft in Maryland? It could match felony theft in DC because the value could be $1,499 all the way down to $1,000. That would still match first-degree theft in DC. But it could also be less than $1,000, in which case it would match misdemeanor theft in DC. So what CSOSA would do is they would initially score this as the least severe offense with a footnote saying this offense could match first-degree theft or it could match second-degree theft. It was initially scored as the least severe offense. But remember, when I talked about how you can bring in the facts of the case to the sentencing judge to try and prove by a preponderance of the evidence that it should match a different DC offense, here the government could bring in the facts of this underlying Maryland conviction. And if they could prove by a preponderance of the evidence to the judicial fact finder that the value was $1,000 or more, the judge could change the scoring of the conviction from a misdemeanor at 0.25 points to 1 point for a felony conviction. Virginia's entering a dwelling to commit a felony operates in very much the same manner. So in DC, burglary 1 requires an occupied dwelling. Burglary 2 does not. In Virginia, entering a dwelling to commit a felony does not have a requirement that the dwelling be occupied. So it could match burglary 1 or it could match burglary 2 in DC. It would initially be scored as burglary 2 with a footnote saying it could match burglary 1 or it could match burglary 2. It was initially scored as the least severe offense. And once again, the government could try to introduce evidence, and this is the only time we start looking at the facts of the underlying conviction, is they could introduce evidence to the sentencing judge to try and prove by a preponderance of the evidence that there was actually an occupant in the dwelling at the time the offense occurred, and therefore the judge could change the scoring from burglary 2 to burglary 1. Now, at the very beginning of this presentation, I talked about that there was a non-substantive change to the multiple offense versus single event rule. And that rule says that only the most serious offense arising out of a single event is scored. So as part of someone's prior criminal history, if they have multiple offenses as part of the same event, and events can cross over jurisdictions. So it could be Maryland convictions and DC convictions. They could be part of the same event. If that's true, you only score the most severe offense. So it's very important in making the determination whether or not something is part of a single event or multiple events, where it could be scored either once for a single event, or if it was multiple events, you could score different convictions. This is always a factual determination because the rule is it's a single event if it's committed at the same time and place or has the same nucleus of facts. That determination is initially made by the pre-sentence report writer and ultimately finalized by the sentencing judge. The sentencing commission never weighs in on factual issues or factual determinations. Therefore, the rule has been modified just to specify that the sentencing commission will not weigh in on this. It's a determination initially made by the pre-sentence report writer that then can be challenged by either party to the sentencing judge to make the ultimate determination. But the sentencing commission can't help in making that determination or any other factual determination. That's just not the role the commission plays. So, special rules for out-of-district offenses, so scoring offenses that occurred before a defendant's 18th birthday. And much like we've talked about throughout this presentation, we're really trying to treat the defendant as they'd be treated if the prior adjudications or convictions occurred in DC, even though they occurred somewhere not DC. So a prior conviction where the defendant was less than 15 years old is always treated as a juvenile adjudication. Because in DC, if you're less than 15, no matter what, your offense cannot be charged in adult court. It's going to be in the family division, and if you're ultimately adjudicated, it becomes a juvenile adjudication. For individuals above 15 at the time of the offense, with one exception that I'll get to in the next bullet, A prior conviction where the defendant was 15 or older is scored as a juvenile adjudication unless the court finds by a preponderance of the evidence that a judicial hearing was conducted in the out-of-district jurisdiction to determine if the case would be transferred or retained in adult court. So if the person's 15 years or older, for that to be treated as an adult conviction, even if they were tried as an adult in the out-of-district jurisdiction, there needs to have been a transfer hearing. If the judge does not find by a preponderance of the evidence that such a hearing occurred, then the scoring is always going to be as a juvenile adjudication. The one exception to that rule is a prior conviction comparable to murder, first-degree sex abuse, robbery while armed, or assault with intent to commit any of the offenses, and the defendant was 16 years or older at the time of the offense, can be scored as adult convictions if the defendant was tried as an adult at the time of the offense. If they were still tried as a juvenile in the foreign jurisdiction, it will still be a juvenile adjudication. But if they committed one of those listed offenses, were 16 years or older, and were tried as an adult, then that can be treated as an adult conviction in DC, in much the same way that those enumerated offenses, when someone's 16 years or older, can immediately be brought in adult court in DC. The last thing I want to touch on today is pretty rare, but we like to throw in rare things at the end of presentations like this just to keep it in everyone's mind if you ever see it. And that's the scoring of military, territorial, and foreign convictions. So prior military convictions can be scored if they were imposed following a general or special court-martial. But if the conviction was imposed following a summary court-martial or an Article 15 proceeding, that conviction is not scored. Federal convictions from U.S. territories, like Guam, the Virgin Islands, and such, are scored. Local convictions from U.S. territories are presumptively scored. However, the defense can argue that if the territory's criminal justice system doesn't provide sufficient procedural protections, they can argue that to the judge, and if the judge found that was true, then those convictions also would not be scored. Foreign convictions, and in this case, when I say foreign, I mean foreign states like Canada, China, New Zealand, those convictions are never scored. Appreciate you sticking with us through this, including my ill-timed phone call. I apologize for that. The Commission's here as a resource for all practitioners, defense attorneys, government attorneys. We're here to support you. If you have any questions about how something's scored, how the rules are applied, how the rules work, please feel free to reach out to us. We really try to be a resource to make sentencing a little easier in the District of Columbia. So I would encourage you to contact us. I appreciate you taking the time to review this PowerPoint with me. If you got any questions, give us a call. Thanks and have a great day.